Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we're going to talk about how much should you pay for a lawyer. If you find this video helpful, please subscribe to the channel, like the video, and hit the notification bell so you can keep up to date with all the videos that are coming. Thanks to those of you who have subscribed and stuck around. It's just been an amazing experience. I thank you all. And if you have any comments, please be sure to put it down in the comment section what you think about this topic. So the reason why I'm talking about how much you should pay a lawyer is I got an email newsletter from the ABA Weekly, and the article said that a lawyer had charged a fee of almost $2,000 an hour. I believe it was $1,950. The lawyer's name is David Boy or Boyes. I'm not sure exactly how to pronounce the last name. But in a court document, it showed that he was billing $1,950 per hour on a case. And when I heard about that, I thought, wow, that is a lot of money per hour. You know, some people think I charge a lot, and my fee ranges between $400 and $500 an hour. And this guy ranges in the $1,900 to $2,000 an hour range. And if you go through that document showing all the different fee structures for the different lawyers in that firm, he's not the only one that is over $1,000 an hour. So how much should you be willing to pay per hour for a lawyer? What is the proper amount for a lawyer to charge a client in a certain given situation? Well, every state has adopted some form of professional rules of conduct, and those rules dictate how much a lawyer is allowed to charge, but it's based on certain factors. Virginia has adopted a rule that is pretty much like the ABA model rule, and the ABA model rule is what's taught in law schools, and most states have something that's either identical or substantially similar to the ABA model rule on fees. So there are 8 factors that the ABA requires lawyers to go by in determining the reasonableness of a fee. The first factor is the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. So the amount of time that is worked on, the type of work. Is it a novel issue? Is it something that is very straightforward and simple? That would probably weigh in favor of less money. If it's a complex issue, that would weigh in favor of more money. And the types of questions that are involved. So that would be one factor that the lawyer would need to consider in charging a reasonable fee. A second factor is whether the case that they are taking is going to have some negative impact on the lawyer's ability to accept other cases. So if they are recognizing that there's a certain type of case that comes in the door that's going to take away hours and time and skill from being able to take other cases or less amounts of cases, then the lawyer may be able to lean in charging a higher fee. Whereas if it's just a simple run-of-the-mill type of case that's not going to preclude the lawyer from being able to take other cases, that's going to weigh in favor of it being a lesser fee. The third factor is the fee customarily charged in the locality for similar legal services. What this factor is saying is, what are other lawyers charging in the area for similar legal services? But here's the problem with that. There are actually legal ethics opinions and rules that prevent lawyers in a community from getting together and asking each other, hey, how much are you charging? How much are you charging? So that they are not charging the same thing and basically making sure everybody's charging a higher price, which would then cause essentially a monopoly of equality where everyone is able to charge the same high fee. So I'm not exactly sure how this would be applied, and I've always wondered this from law school, because if it's colluding to contact other law firms and find out what they're charging and charging something similar, how would the ABA or the local bar or even the state bar of each state be able to determine the reasonableness of the attorney's fee based on the locality? Because it would seem unfair to require the attorney to be held to a standard that they're not allowed to be able to discover. But nevertheless, that is one of the factors that are considered. The next factor is the amount involved. So if it's a case that involves a large amount of money, or if it's a lesser amount of money, or the stakes are high, stakes are low, that will weigh in favor. And then, of course, the results obtained. Now, here's the other thing. The bar doesn't allow attorneys to guarantee results. It is illegal for a lawyer to say this is going to be the outcome, which is why it's called the practice of law. And yet they consider the results obtained as a factor. So again, that's a factor that seems to be unfair to the attorneys in making their financial decision making, because that's a backwards looking aspect as to the reasonableness of a fee, not one that at the time of contract, at the time of entering into an agreement between an attorney and a client, all of those aspects could be determined right there in the contract. Instead, this is allowing the bar to be able to look backwards and say, okay, well, here was the result, so was it really worth what you charged to begin with? And when you can't guarantee a certain outcome at the beginning of the contract anyway, how is that a fair measure for reasonableness? So, but again, that's one of the ones that's listed in the ABA model rules. The fifth factor is the time constraints or time limitations required to take care of the client or of the circumstance. So if it's a very needy client that wants to, have access to the lawyer at any time, all hours of the day, I'm hiring this lawyer, I expect them to answer my call immediately, just like that. Well, that person should expect to be getting a higher fee. Whereas if you're able to talk to a paralegal, receptionist, leaving message, going through other channels of communication where the time constraint isn't so much, well, that's going to lean more in favor toward a lesser fee. And then, of course, of the circumstance itself. Again, that's kind of more goes back to factor one, is how much time is required. But they're putting this extra word in there, I think, just to kind of assuage clients to say, hey, look, if you're going to be needy, that's going to cost you more. If you're going to be less needy, then it's going to cost you less. The sixth factor is the nature and length of the relationship between the client and the attorney. So if they've had prior engagements, prior relationships, then that's going to be a factor that the bar looks at. I don't know what that has to do with the reasonableness of the fee, but that's one of the factors that they look at, is whether this is a one-time client or if this is someone that there has been a lengthy relationship. That's a factor that they look at. The seventh factor is the experience, reputation, and ability of the lawyer or lawyers performing the services. If you want to have the gunner, you want to have the one that when they go into court, they're respected. They're the judges, they get the good rulings, and it's not because they have any relationship with the judges, because they know the law, they've got the experience, they've been there, done that, got the t-shirt. And it doesn't even necessarily matter, about length of time in and of itself, because there's a lot of lawyers who are bad lawyers who have been bad lawyers for a long period of time. But the issue is what is the experience and their skill level as they come to the table. So, for example, if I've been doing custody cases for over a decade, which I have been doing, and I kind of have a system and have experience in knowing what needs to be presented to the court, I don't have to charge the same amount that a first-year lawyer is charging on a custody case. I don't even have to charge what a 40-year lawyer charges on a custody case if they don't have the experience and skill in knowing how to do that. Because I may have done more custody cases in my limited amount of time than even the older lawyer who's been doing it longer. But that is a factor that the bar looks at, is the skill level and experience. That information may come from reviews. It may come from being able to check court records and other things. For example, I've settled some big personal injury cases. So that information, some of it's out there, but some of it is confidential settlement. So you wouldn't know about those things if you tried to dig around in some of those things. So I try to get them in reviews. But if they don't want to leave reviews for whatever reason, they just want to keep their stuff as private as possible, you may not know my skill level. But I'll be able to explain that to you, or one of my staff will be able to explain that to you in the consultation, to be able to say, look, this is what he's done, this is the experience he brings, this is how much he charges. And if you say, well, so-and-so is charging this amount, well, then I'm going to explain to you why I'm charging differently than so-and-so. And if you want me, this is how much it's going to be. And if you want so-and-so, go get so-and-so. And that's pretty much how it goes. And that's one of the factors that the ABA looks at. The last factor is whether a fee is fixed or contingent. So the primary billing method for payment is hourly. So it's an hourly rate. So in domestic relations cases, especially contested divorce cases, most lawyers charge an hourly rate. But there are some lawyers who charge a fixed rate, which is a fixed set amount, where the lawyer generally keeps up with the number of hours. But instead of it being, billing every hour and sending a bill and having this monthly payment, it can be based on work performed and set up in certain ways. That would be a fixed structure. Or there's a contingency structure, which would be like what happens in most personal injury cases, where a lawyer says, I'm not going to get an attorney fee unless you get something. So if you get a $120,000 personal injury settlement, and the contingency agreement is that the lawyer gets a third, plus any costs that were fronted by them, like the filing fees or requests for medical bills, copying, other types of out-of-pocket costs, those get reimbursed prior to the fees and the payouts and all that stuff. But just for simplicity, let's say that there was no cost, it's a $120,000 settlement, and the contingency fee is for a third. Well, then the lawyer will get $40,000 and the client will get $80,000. And if the client were to get zero, they go to jury and there's a zero verdict, then the lawyer gets zero. So it's a big win if the lawyer wins. It's a big loss if the lawyer loses. So that's what a contingency fee is. And the factors for the ABA, this factor considers whether the reasonableness based on whether it was a fixed or contingency fee. So to ask the question, is this attorney worth $1,950 an hour? Well, based on his bio and all of that information, he's been doing this for a long time. He's got lots of experience. He's at a well-known firm. He's engaged in high-profile cases. He's going up against Google. So I think he certainly has an argument that a $1,950 an hour rate is reasonable. Now, should you pay an attorney that much for your divorce? Well, maybe if you're Johnny Depp or you're some other famous person. But if you're middle class, upper middle class, even that kind of hourly rate is probably not going to be a reasonable amount. Now, that doesn't mean that the lawyer has to take your case if you're not willing to pay that amount per hour. And so that is a factor that the ABA will consider, is that if the lawyer doesn't want to take the case and says, I'm not going to take the case unless you pay this much per hour because I don't want to do the case, and you say, well, I want you to do it, and then later you go to the bar and say, hey, they didn't charge me a reasonable fee, that's going to be a factor that the bar is going to consider, is that, look, he didn't want to take the case. He said he would take it for this amount per hour, and you agreed to it based on his years of skill and experience and all these other things. He didn't want to do it, but you paid him anyway. Obviously, I can't say what the actual outcome would be, but in my opinion, I would think that the bar would be okay with that. But you put in the comments, what do you think? Is there any reason why any lawyer should make $2,000 an hour on a case? What do you think? Just put in the comments and let me know what you think. While you're down there, subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.